financial abuse for you guys. So financial abuse is unfortunately one of the largest crimes committed against our older Canadians. And we just wanted to share a few ways that you guys can prevent it and keep yourself safe. So one of the most important thing is securing your personal information. So not sharing name, address, social insurance numbers, date of birth, any of those things with anybody that you don't know and trust. And that includes making sure that your family members and that aren't sharing that information anywhere. You want to make sure you're appointing a power of attorney that can act on your behalf, somebody that you trust. We're going to get a little further into a power of attorney in a little bit too. And not being afraid to say no. If it doesn't feel right, it's probably not right. So don't be afraid to say no to people if they're asking you for information that you don't feel comfortable giving. Fraud is one of the #1 crimes that are done against our older Canadians. If it's unusual, so if it's an odd request, so I've had a client have somebody ask them to go buy gift cards to go pay the CRA. The CRA does not get paid in gift cards. It just doesn't work that way, but he was out like $6,000 over it. It was awful. It happens because those people are professionals and that's what they're designed to kind of talk you into it. It's not right. If it doesn't feel right, it's not right. And then also making sure you're protecting your information on the internet. So using complex passwords that aren't easy to guess, but you know them, and don't share them with anyone either. Having your antivirus scans and firewalls up to date, and using those to make sure. And then there's also 2-factor authorization info alerts that you can use as well. So Scotiabank, for example, has like a 2-step verification. So when you log into your online banking, it'll actually send a notification to your cell phone if you have one that you then have to put a code in so that it's definitely you that's logging in, for example. Yeah. There is a fairly new thing that came into effect with legislation at the beginning of this year called our trusted contact person. So anybody who has investments out there may have heard of this. It's what it is it's a person that you appoint to be your trusted contact person for your financial advisor. So if, for example, your financial advisor felt that something was off or you were being taken advantage of or you weren't cognitively all there anymore, they may make some changes, or they may call that person, just to say, hey, I have some concerns, I'd like you to call that person and we should talk a few further things. It is different than a power of attorney. The trusted contact person cannot make financial decisions on your behalf. Okay, so it's just somebody that we can contact to discuss things. You have a question?
Yeah, what kind of intervention can a trusted contact person do if something is suspected?
So the idea would be that it would be somebody that you trust that we can then call and say, I have some concerns, and then it would be what would be the next steps would be based on what that concern would be. I kind of explain it as it's actually really just breaking our privacy laws, kind of. Like it's giving an in to the privacy laws for the bank. So because as a Scotiabank employee, I cannot share any of your information with anybody. If they came and asked if you banked with me, I had to say no even if you did, or I don't know, or something like that, just for privacy rules. This allows us to call somebody and say, hey, there's a problem. Does that answer your question?
Yeah, pretty much.
Okay.
So they don't actually have access to your information. They can't actually do anything with your information. They're just there as a kind of backup to say, oh yeah, this is okay. This outside contact is okay.
They may they may also have the contact. If the financial institution isn't aware of who your power of attorney is, that trusted contact person will likely know who then we can contact in order to perhaps enact that power of attorney or to meet and discuss what is going on and get down to the truth of things. I recently had a client come to me. She was concerned about her father's financial affairs. She had a legal power of attorney. Her father wasn't present, but we had the documents on file. So we were able to investigate a little bit further into his financial affairs together. And it turned out that he was just spending a little bit too much money. It didn't turn out to be in anything fraudulent, but it was, a way for us to be able to help protect him, and it gave her some peace of mind as well. So we'll get into power of attorneys a little bit later, but trusted contact person, it's very new, so you may not have heard of it, but if you're working with your financial planner, they're going to be, ensuring that we do have that second person. It could be your spouse, it could be your sister, it could be your son, it could be your daughter. We recommend that it is not your power of attorney, just so that it is somebody that is non-biased. So for Jessica and I, we'll get into this a little bit further too. For Jessica and I, we only have a certain number of clients that we deal with, and so we know our clients really, really, really well. And we suggest that you do, find a financial planner that you trust and that, gets to know you from a long-term basis, maybe even meets your family. And that way we can notice when there are transactions, things that aren't typical, or maybe we just have to ask one more question. Yeah, for sure. Okay, well, we'll get into investment consolidation, which is something I just touched on. So I know you've all heard this term before, putting all of your eggs in one basket. People usually tend to say that that's not a great thing, but sometimes putting all of your eggs in one basket can maximize opportunity and simplify things for your loved ones. So holding your investments in a variety of financial institutions sometimes can feel like an effective way to diversify. Maybe you get a better rate at this green bank and then this blue bank or this red bank. But it could be holding you back from really reaching your long-term goals. And it also could cause confusion for your loved ones that may need to assist you eventually. So one central point of contact for all your investment and banking needs is really what we suggest. So honestly, what Jessica and I do for our clients, we provide a financial plan, and a binder. All of your investment statements go in here. We've got your investment financial plans, investment statements, anything else like tax receipts, things like that. This can all be in a centralized binder, so that if you do need to have someone assist you, everything's in one place. So, you could also take this own approach on your own if you did have multiple financial institutions to create your own financial binder that does have all of the information that you need. I wouldn't, per se, put your social insurance number and things like that in there, but would definitely be any pertinent information for somebody who needs to take over and help and assist if that time should come. So another good thing about simplicity is just that, reviewing multiple investment account statements on a monthly basis can be very confusing. It's difficult to track overall performance of your portfolio. When you combine everything in one financial institution, it makes it convenient, it's safer, you get to know each other, your financial planner and yourself. It can cut down on the number of tax slips, and it can really allow you to keep a better track of all of your holdings. And again, it makes it much easier for your loved ones to assist you. Okay, so I am pretty sure everybody in the room knows the current circumstances in our world. We've got, Russia and Ukraine crisis right now, which is extremely sad and horrible. We have, interest rates increasing at a very fast pace. But we've had things like this, the bubbles here, the Brexit, trade wars, government debt, US shutdown, UK elections, ongoing UK elections, global economic slowdown, the pandemic. We've been here before, so we're no strangers to bumpy rides when it comes to your investments and your investment performance. Markets aren't predictable, so none of us can stand here and predict to say what's going to happen in the future. We don't have a crystal ball, but our behavior is usually pretty predictable. So we typically end up going through a cycle of market emotions. So you tend to get become an optimist when the markets start to do, good things and stock prices are increasing. And then you start to get excited and thrilled, and then all of a sudden, oh my gosh, I can't believe how well my investments are doing. This is fantastic. And then a bump in the road comes, and then we start to get a little anxiety. We go through fear, get to the point where we're at despair. We might be in a point of despair at the moment, if you received your September statements, but we know that this is actually a point of maximum opportunity, so sticking with your long-term plan is really key, and just ensuring that you have a really great financial advisor and investment specialist that can help you talk through these times. As eventually we'll get back to that spot of optimism, and typically coming out of turbulent times like this, the good times last for about 10 years. Again, patience is a virtue, and so when we look at recovering from typical market conditions such as they are today, this is just an example of Canadian equity markets. So after major downturns, which we pretty much had, right? So you can see there, between, it's tough to see, but this just illustrates 3 months after the volatility ends, 6 months, 1 year, 3 years. So the gold bar would be 5 years after, and you can see that that's 77 to 118% return on your investments. All right, we're going to talk a little bit more about power of attorneys. And please let us know if you have any questions. This is a very complex conversation and a lot of information. There's a lot of misinformation out there as well, so hopefully we can provide some clarity.
Okay, so there is.
More into the mic.
Sure. Maybe.
Thank you.
Is that better? Okay, good. Okay, so I just want to make sure everybody knows there's a difference between having a power of attorney and an executor first, okay? So the executor is of your will when you're no longer with us. Power of attorney is while you're still with us and if you need some assistance kind of thing. So power of attorney gives someone of your choosing, so your attorney, the right to act on your behalf if you could not do so yourself. So there's two different kinds. There's one for property and one for personal care. Your personal care is for healthcare needs. So we're going to talk more about the, my brain's lost. Thank you. I'm like, what happened? The continuing power of attorney for property. So it allows them to make financial decisions on your behalf. So you can have those drawn up by, say, a lawyer can do those up and choose your power of attorney for, not choose your power of attorney for, you choose who you would like to be your power of attorney. And you want to make sure you're choosing somebody that you trust because they will have access to your information and your accounts and that. A general power of attorney is the legal document your attorney makes. So it's one that's used when you are mentally capable or until you revoke it. So it would be put up. If you became mentally incapable, that becomes null and void. It wouldn't work. It would not work for you any further. So the general power of attorney is usually used for short-term needs and business types of things. So you can legally appoint one through your lawyer, but your financial institutions also provide the option to appoint your own continuing power of attorney on each of your own accounts. You're able to revoke those at any point in time. If you provided a legal power of attorney at a later date, that would automatically supersede your one that you've made through your financial institution as well. And you can put restrictions in place on those as well, where you're only allowing them to do specific things with the power of attorney.
Does anybody have any questions?
You didn't mention that in doing a power of attorney, one has to appoint, their primary one, but also a secondary person. You always have to have a secondary person as well.
Definitely a good idea, for sure. Yeah, when you're doing a legal one, you'd do a primary. Some people actually will have more than one person as their power of attorney as well. So you can have like this person and this person, or this person and or this person as well. So you can choose multiple power of attorneys if you wanted to as well. But definitely a good idea to have a secondary.
Just show of hands, how many people have a legal power of attorney in place? Oh, that's fantastic. That's awesome. Okay, great. Raise your hand if you have a power of attorney, a general power of attorney for something like you went on vacation and you just need someone to pay your bills. Okay. So at your financial institution, that is an option. You can elect a temporary power of attorney using that general power of attorney, and you can place a restriction on it. So say this person just has access to your checking account and is only allowed to pay bills. That is it. So there are those options at your financial institution should you need to. You don't always have to have your continuing power of attorney be the one to take on all of the responsibilities. Good. All right. So jointly owned assets. Estate planning is about ensuring that your assets are distributed in the way that you wish and minimizing the burden of your loved ones after you pass away. So does it matter if your assets are jointly owned? Well, Jointly owned assets give the joint owner rights of survivorship. This can be convenient and practical. Joint assets pass outside your estate and they go to the surviving owner. This can save time and money and the administration of your estate. However, there are some advantages and disadvantages to these jointly owned assets. So the advantages would be ease of having someone pay your bills for you should you need assistance, a second set of eyes to go over your finances, and it also can help avoid probate fees. Disadvantages, you could have loss of control. Assets can be depleted without your knowledge. So these assets, if you make an account joint and that anyone can sign, that means the other joint owner can take money whenever they choose, and there's no stopping that. There is a way to make a joint account that all to sign, and therefore both of you would need to be present at the time that a withdrawal would happen. There is also a risk of exposure to creditors. The joint account owners, each owner owns the asset, and so therefore there could be concern that perhaps the other joint owner, wasn't necessarily in a position where they have been paying their creditors on time. Also marital breakdowns. This could become part of matrimonial assets of this other joint owner. So there are very fine lines about where we would suggest having a joint account with someone other than your spouse. There could also be unintended tax consequences. So from a taxation standpoint, interest, capital gains, and dividends can usually be assigned to the primary account holder. However, they can be split between joint owners as well. Capital gains and dividends, if you were liquidating an investment at the end, the joint owners are both responsible for those. And so there could be unintended tax consequences for that. And there is a loss of privacy. So, you would lose the privacy of being able to make transactions without someone else knowing what you were doing. And so that could be a disadvantage as well. Anyone have any questions?
How does this apply to real estate?
So it'd actually be very similar.
Could you repeat the question?
Oh, yeah, sure. So the question was, how does this apply to real estate? So that's a tricky question in the sense of if the two owners were joint on the asset at the time of purchase, right? Then they would have to both sell the house. So it would be both signatures from real estate standpoint because you would have a lawyer involved. If you were to add somebody onto a property that you already owned, this would also be done by a lawyer. And so therefore, there would be potentially independent legal advice that the lawyer would ask for you to have, for the person coming onto the property would have. And in terms of capital gains and upon the sale of the property, should it not be a primary residence, that could be contested by the CRA. It's not black and white. So that would be one of the disadvantages, unintended tax consequences.
And if you were transferring it for financial consideration, the person doing the transfer, it would be a capital gains hit at that point.
Correct, yeah. Sorry, the question was, or the statement was that if you were initiating the transfer, there would be a capital gain for that person. If there's financial consideration. That's a tax accountant can of worms to open. All right, so taking advantage of tax-free savings accounts. Everybody in the room have a tax-free savings account?
Yep.
Awesome, okay. So this was a program that was created by the CRA in 2009. They've been existent for more than a decade, but many Canadians, unfortunately, it remains underutilized as a wealth accumulation tool. So how does that account benefit you? In a tax-free savings account, you have the flexibility to invest in similar securities as you would in your retirement savings plans or non-registered savings account. Canadians can grow their investments and savings much faster because the income and the growth, the return on your investment, is completely tax-free. This is also because you're using after-tax dollars to contribute to your tax-free savings account. There is a way to income split using tax-free savings accounts. So this is an effective way to help split income amongst family members, such as your spouse or your adult children. You may provide a gift to help them make a contribution to their TFSA. They would be responsible for their own account and contribution room, but the income tax attribution does not apply on TFSA earnings if they're tax-free. You can also use TFA, a tax-free savings account, as a benefit for estate planning. So tax-free savings accounts help minimize taxes upon your death because the maximum value of your estate, which is especially important for high net worth individuals. If you name your spouse as a successor holder, then they will maintain that account in its tax-free status without affecting their own contribution room. You could also name your children as beneficiaries, which allows them to inherit the account directly, avoiding probate fees. And you can note that the tax-free status is lost on death when the account passes to that beneficiary, but your children could then use that inherited tax-free money to contribute to their own tax-free savings account. Question?
What's a contribution room?
The question was, what's a contribution room? So,
6,000.
yeah, the government couldn't make it any more confusing. But in 2009, it began with a $5,000 contribution. It was supposed to increase with inflation. It did increase to $5,500, and then the Conservatives got in and increased it to $10,000, and the Liberals got back in, and they decreased it to $6,000 per year, correct? And that does accumulate. So if you haven't contributed to a tax-free savings account today, you have $82,500 worth of room to contribute. Yeah?
If you gave your money to TFSA, you gave that to your children, would that avoid probate?
So the question was, if you were to leave the tax-free savings account investment to your children, would that avoid probate? The answer is yes, that money goes directly to your children or your beneficiaries, completely tax-free. And
So what if you put all of your money in? Well, of course you can't return to it on your own.
yeah, unfortunately, you can't put all of your money into a tax-free savings
To
account.
avoid probate.
Yeah, I know. So, probate is one of those things where I think there's a misunderstanding about what it is and how expensive it can be. I mean, it's a fee, that the government charges to make sure that, your assets and your will are your last true testament, and that your wishes are granted appropriately. And so that's there to protect you, but there is a fee, of course, it's government, they want our money. But it isn't necessarily as large as maybe you may think it is, again, depending on your net worth. So avoiding probate is something, we talk to our clients about, and when we're completing a financial plan, it's something that we discuss with our clients, but it isn't always the best suitable option to just try to avoid probate. So, but a tax-free savings account is a great way to avoid probate.
Thank you.
Question?
Is probate a percentage of what your investments are?
Correct. On the first $50,000, there is no fee, and then it is a percentage based on the amounts, and it's a graduated scale. Yeah. Yes?
The 85.5 max for a TFSA so far since 2009, if you put in monies at two different banks, at your two different TFSAs, it's still all, you have to count it as one amount, you have to add the two, right?
Correct. Yeah. The question was, can I contribute $82,500 to, sorry, 85.5, my apologies, to financial institutions? No. If you have two tax-free savings accounts, the total contribution room has to accumulate to the maximum of 85.5.
Now, if I've gotten monies because of family who's died, I'm aware from my lawyer that it's tax-free anyway.
Correct.
Because it's through that. Where shall I invest monies like that? If it's gonna be tax-free anyway, I don't have to quote hide it, do I?
So the question was, I received an inheritance. Is it tax-free? The answer is yes, we do not have an inheritance tax in Canada. So when you receive money through an inheritance, it is after-tax money if it was taxable. And the second question was, what can I do with that money? So,
Give it to me.
So if you have the room in your tax-free savings account, that is the first place we usually recommend clients investing, because it should be your most aggressive, longest term investment because it is tax-free. So any growth, so for example, you buy a GIC, the rate is 4%, that 4% interest is tax-free, the government never gets their little hands on it.
So what I did was I did a 50,000 personal redeemable GIC recently at Scotiabank.
Okay, great.
Put that inside a TFS.
Perfect.
Does that mean I could only do 32.5 more in the same fashion?
Correct.
Because I just did 50?
That's correct. 35.5.
What shall I do with the rest of it?
Right. So, the question is, I've received more than 85.5, and what should I do with the money at that point? So if you're under the age of 71, the option would be to contribute to an RSP to shelter some of that money. If you are over the age of 71, or if it doesn't make sense to contribute to an RSP because perhaps your income tax level isn't high enough for the return to be of benefit to you, then a non-registered savings account or a non-registered investment account would be your next option. So inside a non-registered savings account, you can hold GICs, you can hold stocks, you can hold dividend funds, mutual funds, a variety of different investments. So there's really a lot of variety there. From a taxation standpoint, in a non-registered savings account, your highest taxed investment is going to be a guaranteed investment certificate or a GIC. Interest income is earned and it is taxed at your marginal rate. So if your marginal tax rate was 32%, if you made 4% interest, you would have to pay 32% of that interest to the government on your tax return. Dividend income and capital gains are much more tax efficient, and you can get those through, dividend-paying stocks, mutual funds, things like that. Yes?
If somebody gave me some good money, not like it, but anyway, what if I gave some of that money to my kids for them to invest? Would I be penalized, or would they be penalized?
So the question was, if I had extra money and I wanted to give it to my kids, would I be penalized or would my kids be penalized? So it would be considered a gift, and there's no gift tax in Canada. So you would be able to gift that money to your children. Again, I would caution you because the disadvantages that we talked about in terms of jointly owned assets are similar to when you gift money to your children. So the disadvantages would be that you lose control of that money, but if it is truly a gift, and then you're allowing them to do what they wish with the money. Again, marital breakdowns, so that can cause concern should there be a marital breakdown, because it could become a matrimonial asset. If your children were to inherit money after you passed, right, then that money, as long as your children do not make that account joint with their spouse, it is not part of the marital assets. But if you were to gift it to them, there is a fine line where you may need to have a agreement drawn up with a lawyer that your children may have to have that drawn up to state that this was a gift and it is not part of the marital assets. It's a very tricky situation. Yeah. Question?
I have one child living in Canada and one not living in Canada. So the one that lives here is okay. The one that lives abroad, where do the taxes fall for that person, or do they?
So the question was, I have a child that lives in Canada and I have a child that lives outside of Canada, and if I was to gift them money, is that where if I was to gift them money, in your will, okay. So it is, I'm not a tax accountant or a lawyer, but it is my understanding that that money is still tax-free regardless of where that child lives. Yes?
I'm moving to England
Oh, wow.
in 3 or 4 months' time, and I just wondered, with my assets, would the Canadian government tax me?
Again, I'm not a tax accountant or a lawyer. However, I do believe because of the Commonwealth, there's an agreement between Canada, the UK, Australia, and so forth, that you are able to move without, and your assets are able to move to those countries without any tax implications.
So I will not be taxed. I've had 2 different lawyers, and not one of them is clear about it.
You might want to check with an accountant.
Accountant.
But the other thought I wanted to say is once you've left the country, you're no longer a resident, so your tax-free savings account contribution amount stops. You wouldn't get any for the next year.
So if I left my assets or whatever
What you have now is okay.
Canada, I would be okay?
Well, what you have now is okay, you just wouldn't be able to contribute any further to your tax-free savings account.
Oh, okay, thank you.
It's my contribution.
Any other questions? Okay, all right. We're gonna get into estate planning and wills.
Okay, so for the estate planning is about ensuring that your assets are distributed in the way that you wish and minimizing the burden on your loved ones after you pass away. So I hope that everyone has a will in place. And if you don't, you need to call a lawyer as soon as this is ended and go make an appointment because it's really important for everybody, especially for your loved ones after you're gone. So it's really important and it will legally protect your loved ones and your assets to make sure. So how often should you update your will? You should update your will anytime you have like a material change to it. So anything significant that happens in your life, there should be a change. So if you've been married, divorced, there's been a death, anything like that, significant health events, that kind of thing, you should make a change to your will or at least review it and see if there are any changes needed. Who should I name as an executor? Oh, I'm sorry. Where?
Don't have a will, does the money automatically go to your spouse if he or she is alive?
So the question is, if you don't have a will the money automatically go to your spouse? That's a tricky question, actually, because not necessarily, especially if it was like a second marriage or something like that, because there could be kids saying that money belongs to them as well. So that's why you want to make sure you have a will in place. They may have to apply to get, what is it called, a certificate of appointment without a will, it's called. So it's basically applying for probate without having a will. And then it would have to go through the government to determine that. So not necessarily.
But when it has only been the one marriage, it would be okay, typically.
Typically it would. Typically.
I'm not planning to do that. Somebody who is.
Fair. Yes.
Any of your investments that you have, do you not specifically say who the beneficiary is on your investments in your bank? It doesn't necessarily have to be in your will?
Yes. So the question is, if you have named beneficiaries on your investments through the bank, does it not go through your will? That is correct. It does not go through your will on your registered assets. So a non-registered account is not an RSP or a RIF or a tax-free savings account. You can't name a beneficiary on that account. So if it is only in your sole name, it would be up to your will what it is, who it goes to. Yes.
Is it true that after 10 years, a will is no longer effective? That you need to redo it?
No.
So the question is, if after 10 years, if a will is no longer effective, I have never heard that. No, I don't believe that's true. You can have a will forever.
Yeah, I've used a 1976 will.
Good.
Yeah.
Good. Yeah. We're good? Any other questions so far? We're good. So the next thing is, okay, so who we should name as an executor on a will. So it can, like, if there's any complexity to your financial affairs, if there's any sensitive family situations to deal with, an executor is a time-consuming and it's a demanding job. It's a job, honestly. Most people pick a family friend or a family member But given complexities, sometimes an executor, it's a good idea to get like an actual company to do that. That is an option for people too. That you can name like a trust to do that on your behalf if it's very complicated. But otherwise, you would choose a trusted family member or friend or two. That's true too. That's it, we're done. Question?
How much would they charge to do the will, if you got somebody else doing it?
I can
To
answer.
be the executor?
Yeah.
That's Amber.
Oh, so the question was, what could the executor charge? Is that my understanding? Oh, what would the executor charge? It's usually a percent.
What percentage?
What percentage? So it could be upwards to 10%, but it's usually around 2%. It depends on the complexity. Again, that would be a very large estate with multiple beneficiaries would be upwards to 10%. It's very rare that we ever see that.
What if my family is out of town, I'm on my own, what, can they have, let's say something happens to me, do they have access to my banking account?
So just to clarify, the question was your family is out of town, they live far away,
Yeah.
and you're living on your own. My question to you is, do they have power of attorney?
Yes.
Okay,
Both of them.
both of them, okay. So then the question would be, can they assist you from afar? Is that the question? Can they assist you from afar? Okay. So the best thing for you to do is to provide your financial institution with your legal power of attorney, a copy of it, whether you need to or not. Then it would be on file. We keep everything in scanned files, so anyone from telephone banking, to a financial advisor, to a teller at the bank, to a manager, financial planner, someone like us, we can access that document at any time. Currently, I'm trying to handle a sensitive situation with a client, and her son lives in Wisconsin. And so because we had the documentation on file ahead of time, it's a very easy process. If we hadn't, there would be lawyers involved likely. We need to get a document from the lawyer. We need to have attestations done. We've never met the son. He lives in a foreign country, so forth and so on. So if we have the documentation ahead of time, it is extremely important to do that so that just in case something happens, that the bank or the financial institution, credit union, wherever it is, has the information to be able to help you as soon as possible.
So it's the financial planner that should have the deed of my will, you mean?
The power of attorney, you're not obligated to provide the bank with your will. In some cases, we don't need a will to process an estate. It depends on how the assets are held. But a power of attorney is extremely important for your financial institution to have a copy of in the case that you need assistance and you're not capable of assisting yourself.
So they don't need to be on my bank account?
Nobody needs to be joined on your bank account. We just need to have that document scanned into our system so that we could refer to it should we need to. Mm-hmm.
So would you require, if, let's say a family member contacted you and told you that their person who had the account with you, their loved one, supposedly, had a stroke or something,
Mm-hmm.
couldn't speak and couldn't take care of their own business, and so they needed to step in, do you then require something from a doctor or some kind of confirmation that that's occurred?
So that would depend on the type of power of attorney. So if it was a continuing power of attorney, that would be utilized whether you were capable or incapable. However, I will say, as a employee of a financial institution, I must ensure that if a power of attorney presents themselves to myself, that I try to contact the client. If I cannot contact the client, I will only do what's best in the best interest of my client. And therefore, this would not include large cash withdrawals or anything that was not within the realms of taking care of their specific needs, right? So it's very important to understand that your power of attorney must be acting on your behalf and only on your behalf. And it is very sensitive, and we take it very seriously.
Do you ask for are they in a hospital? Like, so that you could.
Yeah, there's like 10 or 20 questions I would ask. There would be 10 to 20 questions that I would ask, yeah.
And then would you call the hospital to confirm that that person was actually in the hospital?
They would not release confidential information to me at that point, no.
So how do you know for sure that that isn't somebody taking advantage of your client?
I think in a case such as that, so the question was, how do I know that this power of attorney is not taking advantage? Number one, remember we mentioned trusted contact person. Number two, it's always great for your financial planner to know a couple of your family members or have their contact information. Number three, we can only act in your own best behalf. So if that power of attorney presented me with a Bell phone bill to pay, I'm gonna pay the Bell phone bill, probably not question it. If they came to me and said, I need $10,000 to purchase some medical equipment, I would say, no problem, provide me with the invoice, and I'm happy to pay the company directly. So there is ways that we can help. And of course, we take it very, very seriously. Jessica and I will stick around for as long as we need to. If you wanted to come and talk to us individually, be more than happy. We've left our business cards there too, so if you wanted to take this offline and send us or call us or email us with any questions that you might have, we'd be happy to help you. Okay.